Hi, my name is David King and I'm a partner in the private client team here at Harrison Clark Rickaby's. I'm joined by Beth King-Smith, who is the partner and the head of the Disputed Wills, Trusts and Estates team. We have seen certain instances whereby, and we're actively looking for this in meetings and sort of posing the relevant questions of people to draw this information out, is where sort of certain promises may have been made to family members or workers on the farm that certain things would pass their way. I think it's a proprietary estoppel claim.
Exactly,
that might fall under.
We'll read quite a lot about proprietary estoppel claims and the farming cases. I think it's very difficult because everybody has an interest in the farmland, so it does make it way more entrenched, I think would be the way to put it, that everybody is so keen to see the farmland in their name that it can make these types of cases extremely bitter and drawn out and costly, because nobody wants to give up the land. And land obviously has generally gone up quite a lot from when the generation now who are dying, when they inherited it or they bought it. The land values mean that people are very likely to become more litigious about sorting out wills to do with land. Farming disputes are something that we see on the increase, I would say. Would you agree with that?
I would. If people are kind of watching this thinking, I may have said something to my cousin 10 years ago about what I might be leaving him. Is that something they need to be concerned about? Do you think it's something that they should raise with us now to take some advice? What would your tips be on that?
Well, I think to effectively bring a proprietary estoppel claim, what it really means is a claim based on a promise. So there are typically three things you need. The first thing you need is that there has been a promise. So the typical promise in this type of case would be, Dad promised me the farm would all be mine one day. So that's the first thing. The second thing you need is a reliance on that promise. So you've relied on the promise that the farm will be all yours one day, and you didn't go off to learn to be a dentist or doctor or a lawyer. You stayed on the farm working because you believed one day it would all be yours. So that's the reliance on the promise. And then the third thing you need is you need to have detriment. So what's the detriment to you having relied on the promise for all those years? And it can be many, many years, 20, 30 years, where people, 40 years even, have just stayed at the farm working, not had much pay because it's all part of the deal that it will all be yours one day, son. And then sometimes in this situation, mum has died, dad then gets a new girlfriend and decides to leave the farm in his will to her. Well, equity will stand in the way of that, because that surely isn't fair. Where somebody has relied on a promise all those years to their detriment, then the law will step in and help.
What's the compensation for that? Is it you should have been paid £12 an hour whereby you receive £4, or is it effectively looking at what asset the person was promised and that they should have?
So a lot of these cases turn on exactly what the promise was made and how it was made over a number of years. The problem with farming communities is that they don't tend to necessarily always share their feelings. So there can be very few actual occasions where people can recall, on this occasion it was a wedding anniversary, it was my wedding, it was a speech for Dad's birthday, but actually trying to remember what the promise was. And then it's a question of trying to prove that was the promise. So it's fulfilment of the promise, if possible, is what the courts will look to do. But it can vary. But in broad terms, if you've been promised a farm and you've acted on that for a long time, then you would likely have a claim under the title of proprietary estoppel.